Chevron is the Mac Daddy of the administrative state. It is a case from 1984 that Justice Stevens wrote. It creates a two-part test I'll describe. But the reason why it's in the news right now is even as we speak, Supreme Court arguments have begun in two interrelated cases that are going under the title Loper-Bright. So that'll go from now until noon today, same time as your show. And it is truly landmark because if this Chevron deference doctrine, which upholds the administrative state, is reversed or limited significantly by the Supreme Court, it is a first major step in clipping the wings of the administrative state. So first, let me do what does the Chevron case do, and then let me talk about Loper-Bright as this occasion to reconsider it. So in Chevron, there was the Clean Air Act, and the Clean Air Act told EPA that they were regulating emissions sources. And then the issue is, well, what was the source? So the Carter administration, drilled down to source as the, smallest pipe or, release valve that might, let some kind of air emission out. The Reagan administration broadened it to say that it should be an entire plant, like imagine a bubble or a dome over the plant. And that aggregation gave companies a lot more flexibility. And the Supreme Court decided they would defer to the Reagan administration interpretation, and it created this two-part test that basically said if the statute's unambiguous, if it's clear, then you follow the statute, and if the agency does something contrary to that, then that's unlawful in its regulations. But if the statute is ambiguous, then any reasonable interpretation of those statutory terms gets deferred to, even by the U.S. Supreme Court. Now, as I described it, it's not, necessarily a crazy result in that case, but over time, the door or the crack of that door from Chevron is just expanded, and expanded. And that brings us to this Loper-Bright case that's being heard right now. In the Loper-Bright case, we're dealing with some herring fishermen who are in Cape May, New Jersey, and they're regulated by this agency that, to me is not obscure, but I think to most folks would be obscure, the National Marine Fisheries Service, NMFS. And I think they like that name as it ties to the sea. They issued regulations that required these herring fishermen to have federal observers. And even if that takes up as much as 20% of their profits from a given haul of fish in order to police, whether they're staying within, their kind of regulations of what fish they can take and, bycatch and things like that. And this is outrageous because the statutory scheme actually only imposes the obligation to pay for these federal observers on narrower classes of fishermen that don't apply to the herring fishermen, and they're capped at 2%, except if you're a foreign fisherman. So these guys are being required to pay 20% just because NMFS said so. And the First Circuit said, it's ambiguous. The statute's ambiguous because it refers to, what's necessary and proper for the agency to do. So we're going to go ahead and allow them to impose this massive tax. So, it would be tremendous to see the Supreme Court, sweep in here and say, look, the Chevron doctrine has gotten out of hand.